Hello guys, this is Samuel Odhiambo, who is a senior law student at JKUAT Current Campus, Nairobi, Kenya. I would hereby once again like to welcome you all to the Samuel Law Podcast and Academy YouTube practice so that together we can get to learn more about our laws. And in today's lesson, we are still going to look at yet another element of contract, which is capacity. Please welcome. So what are the objectives today? After studying this module, we will be able to get the meaning and definition of the term capacity. We shall also be able to understand the different factors that may vitiate capacity to contract. And we shall also be able to identify the contracts that are binding on minors and those that are voidable. And finally, we are going to learn about the remedies that may be used against minors. So let's begin with our introduction. Capacity is another essential element of contract, and in this lesson we are going to learn about the basic requirements of law that one needs in order to have the capacity to make contracts, and also to explain why in law some people and even organizations are not considered to have the capacity to make contracts or to only have a limited capacity to do so. And who are these? These include minors, people suffering from mental incapacity, and even corporations. So we are going to start by looking at the factors that may vitiate capacity to contract. And the first one is minors, or those persons who have not yet attained the intellectual maturity or age. For one to enter into a valid contract, he or she must have attained the age of majority, which is 18 years according to the Family Law Reform Act of 1969. Only such persons are allowed by law to make contracts, since any contract entered into by a minor will be rendered void by the law and therefore unenforceable. According to the basic common rule, minors are not bound by contracts. However, there are some types of contracts which are actually binding on minors, or which are merely voidable, as we are going to see next. Contracts binding on minors. First, we have contracts for goods and services. The only contracts binding on a minor are those for the supply of necessaries, which according to the Sales of Goods Act of 1979 means goods suitable to the condition in life of the minor or any other person concerned, and to his actual requirements at the time of sale and delivery. This includes not just the supply of essentials such as food, shelter, and clothing, but also contracts of service for the minor's benefit. It therefore behooves the courts, when deciding on the issue of capacity, to take into account the social status of the particular minor, as what might be considered necessaries for a minor from a wealthy background may nevertheless be totally unnecessary for one from a poor background. And how do the courts do this? The courts do this by first of all determining whether the goods and services are capable of amounting to necessaries as per the law, and then consider whether they are in fact necessaries as far as the minor before them is concerned. This effectively means that a minor will mostly be bound by consumer contracts as opposed to commercial ones. The Sales of Goods Act also provides that a minor is under no obligation to accept and pay for any necessaries that were sold to him, but prior to receiving them, he felt that they were no longer needed by him. A minor is not also bound by a contract which contains oppressive or exceptionally onerous terms. Whether a term is sufficiently onerous to exclude liability will depend on the circumstances of each case. Where there is a binding contract for necessaries, the minor is only bound to pay a reasonable price for them, and this must not necessarily be the contract price. Contracts of service for the minor's benefit. As aptly noted above, a minor can only be bound by a contract of service providing that on the whole it is beneficial to him. For example, contracts of employment where a minor working as an apprentice can gain some training, knowledge, experience, and even some vital instructions on his future occupation. However, there is no general principle that a contract for the benefit of a minor is automatically binding on him or her. For example, trading contracts are never binding on minors, even where they are for their own benefit. Contract voidable at common law. According to the general rule at common law, a minor's contracts are voidable, which means they are not binding on the minor, but bind the other party or parties. The contracts are thus valid when they are made, but can be terminated at any time by the minor before he or she attains the age of majority or within a reasonable time afterwards. Contracts under this category involve those with a long-term interest in property, such as land, shares, or partnerships. And such contracts will always appear as if they had never been made in the first place if they are terminated before any money is paid or obligations created. Where a minor has already paid money under a contract and then terminates it, the recovery of that amount will only depend on whether he or she got anything in return. What remedies do we have against minors? It's quite clear that the rules on minors and contracts have the potential of creating injustices. For example, in a case where one is totally unaware that the other party to a contract is a minor. This is why equitable remedy of restitution has been applied to minors. If a minor obtains goods fraudulently and keeps them, an order for restitution can be made to make him or her give them back to the claimant. And under Section 3 of the Minors Contract Act of 1987, where an adult has entered into an unenforceable contract with a minor, or where the minor has terminated the contract, any property acquired by the minor under the contract may be given back to the adult by the courts, provided it is just and equitable to do so. In a situation where a minor has already sold or exchanged the property, he may have to pay the cost of the goods or give up any property received in exchange for them. However, a minor who don't have the goods or any proceeds of their sale or exchange cannot be made to pay anything, as this will be tantamount to enforcing an unenforceable contract. If a party realizes that they are making a contract with a minor, they may seek for a guarantee from an adult, which will then make the contract enforceable under the law. In case of any defaults from the minor side, the guarantor will have to compensate the other contracting party for their loss according to the terms of the guarantee. This arrangement is mainly used where loans are given to minors. Now let's look at the second factor that may vitiate capacity to contract, and this is mental incapacity. This category covers those suffering from mental disability, that is mental illness and mental handicap, and also those who are drunk or intoxicated when the contract is made. Generally, contracts made with a person of unsound mind or under the influence of intoxication are prima facie valid until or unless the claimant can prove to the court that 1. He or she was mentally affected and by that couldn't understand the nature of the transaction, and 2. That the other party knew or ought to have known of that disability. Where the above claims are proved, the contract becomes voidable, meaning that the party suffering from mental disability or intoxication can choose whether or not to terminate it. But on the other hand, if this disability is completely unknown by the other party to the contract, the courts will simply ignore the incapacity. Just as we saw with minors, there are no specific rules governing contracts made for necessaries by mentally incapable persons, as they are also subject to the general rule mentioned above. After mental incapacity, we have the third factor, which is corporations. A corporation is a legal entity composed of a group of people which is treated by the law as having a separate entity from the person or persons who constitute it. A corporation cannot enter into any contract as it wishes, as it is limited by a document known as the Memorandum of Association, which lays down categorically the range of activities it can engage in. Any company or business entity that becomes insolvent cannot get into a contract, as it will be rendered void, just as is the case with a person who is bankrupt. So after looking at all those factors, let's come to our conclusion today. Capacity is indeed a vital element of contract. And before entering into a contract, it's advisable under the law for the contracting parties to know and understand each other well, so as to avoid some of these issues. For example, making a contract with a minor unknowingly. Contract law is always so protective on minors, and that is why, even though under the tort law, they can usually be held liable so long as they are old enough to understand the nature of their engagements, this same rule cannot be used as an indirect way of enforcing a contract which would otherwise not be binding on a minor. Let's now have a recap of what we've just learned today. In this lesson, we've been able to learn about the different factors that may vitiate a contract. We've also learned about contracts that are binding on minors and those that are voidable or not binding on them. And finally, we've seen the types of remedies that may be used against minors in a contract to show some form of justice. I would hereby like to offer my gratitude to all of you who have been with me in this lesson, and I do sincerely hope that you've gained at least something out of it. I welcome you all to our next lesson, where we shall proceed with this noble endeavor of getting to understand our laws better. Thank you very much.